Greetings. I hope that this video finds you and your loved ones in good cheer and in the best of health amid these difficult times caused by the coronavirus pandemic. In this video, I will be discussing the relevant rules and jurisprudence with respect to judgments under Rule 119, as well as the rules and jurisprudence governing the various post-judgment remedies available in criminal cases under Rules 120 to 125 respectively of the Revised Rules on Criminal Procedure. Now this video is created for the benefit of my second-year College of Law students to supplement the review on the rules on criminal procedure. It must be underscored, however, that the discussions therein are not comprehensive, as this video serves merely as a review. And with that, we proceed. What is judgment? How does the law and the rules define judgment? Section 1, Rule 120 of the Revised Rules of Criminal Procedure expressly provides that judgment is the adjudication by the court that the accused is guilty or not guilty of the offense charged, and the imposition on him or her of the proper penalty and civil liability, if any. It must be written in the official language, personally and directly prepared by the judge and signed by him or her, and shall contain clearly and distinctly a statement of the facts and the law upon which it is based. In the case of Makahalig versus heirs of Gracia M. Magalit, GR number 141423, November 15, 2000, the Supreme Court had the opportunity to define judgment as the final ruling by a court of competent jurisdiction regarding the rights or other matters submitted to it in an action or proceeding. In relation thereto, in the case of Tung Chin Hui versus Rodriguez, GR number 137571, September 21, 2000, the Supreme Court held that judgment is normally or ordinarily synonymous with the term decision. Now, what are the requirements of a valid judgment? The formal requisites or requirements for a judgment are as follows. First, it must be written in the official language. Second, it must be personally and directly prepared by the judge and signed by him or her. And lastly, it shall contain clearly and distinctly a statement of the facts and the law upon which it is based. Now this is clear, class. The judgment must be in writing. Precisely. In the case of Corpus versus Sandiganbayan and the people of the Philippines, GR number 16221, November 11, 2004, the Supreme Court held that dismissal of the case must be in writing. Otherwise, it is not valid, and it must state the law and the facts relied upon. Again, a dismissal of the criminal case in open court, which was not reduced in writing, is not a valid dismissal or termination of the criminal case. Now, what are the jurisdictional requirements before a judgment may be validly rendered in criminal case? In a criminal case, all right? In the case of Antiporda Jr. versus Garquitorena, 321 SCRA 551, 558, the jurisdictional requirements before a judgment may be validly rendered in a criminal case are: first, the court trying the criminal case must have jurisdiction over the subject matter or jurisdiction over the offense charge. Second, it must have jurisdiction over the territory, or it must have territorial jurisdiction. And lastly, it must have jurisdiction over the person of the accused. Now let us proceed to the contents of a judgment in a criminal case. Now, what are the contents of a judgment in a criminal case? We must first distinguish. If the judgment is for conviction or the judgment is of conviction, it shall state the following. First, the legal qualification of the offense constituted by the acts committed by the accused and the aggravating or mitigating circumstances which attended its commission. Second, the participation of the accused in the offense, whether as principal, accomplice, or accessory after the fact. Third, the penalty imposed upon the accused. And lastly, the civil liability or damages caused by his wrongful act or omission to be recovered from the accused by the offended party, if there is any, unless the enforcement of the civil liability by a separate civil action has been reserved or waived. Now, in case the judgment is of acquittal, it shall state the following. First, whether the evidence of the prosecution absolutely failed to prove the guilt of the accused. Second, it merely failed to prove his guilt beyond reasonable doubt, or in either case, the judgment shall determine if the act or omission from which the civil liability might arise did not exist. Now, the matters which I have just discussed is encapsulated in Rule 120, Section 2 of the Revised Rules on Criminal Procedure. Now, in relation thereto, it must be noted that there are two kinds of judgments of acquittal. In the case of Manamtan versus Court of Appeal, GR number 107125, January 29, 2001, the Honorable Supreme Court elucidated on the two kinds of acquittal recognized by the law as well as its different effects on the civil liability of the accused. First is an acquittal on the ground that the accused is not the author of the act or omission complained of. This instance closes the door to civil liability for a person who has been found to be not the perpetrator of any act or omission cannot and can never be held liable for such act or omission. There being no delict, civil liability ex delicto is out of the question, and the civil action, if any, which may be instituted, must be based on grounds other than the delict complained of. This is the situation contemplated in Rule 111 of the Rules of Court. The second instance is an acquittal based on reasonable doubt on the guilt of the accused. In this case, even if the guilt of the accused has not been satisfactorily established, he is not exempt from civil liability, which may be proved by preponderance of evidence only. This is the situation contemplated in Article 29 of the new Civil Code, or of the Civil Code. Now, question class. What is or what are the effects in case the accused failed to object when there were two or more offenses in the complaint or information? Now, this is answered by Section 3, Rule 120 of the Revised Rules on Criminal Procedure, which provides that when two or more offenses are charged in a single complaint or information, but the accused fails to object to it before trial, the court may convict him or her of as many offenses as are charged and proved, and impose on him or her the penalty for each offense, setting out separately the findings of fact and law in each offense. Again, class, by way of review, when two or more offenses are charged in a single information or complaint, the accused may file a motion to quash prior to his entering a plea or prior to arraignment. Otherwise, it is deemed waived. Why is this? Because of the rule that a complaint or information must charge only one offense, except when the law prescribes a single punishment for various offenses, as provided in Rule 110, Section 13 of the Revised Rules on Criminal Procedure. Now, what is the rule in case there was variance between the offense charged in the complaint or information and that proved? Now, the rules on variance between allegation and proof are laid down under Section 4 and 5, Rule 120 of the Rules of Court, which provides, Section 4, when there is variance between the offense charged in the complaint or information and that proved, and the offense as charged is included in or necessarily includes the offense proved, the accused shall be convicted of the offense proved, which is included in the offense charged. or of the offense charged, which is included in the offense proved. In relation thereto, Section 5, Rule 120 of the Revised Rules on Criminal Procedure provides that an offense charged necessarily includes the offense proved when some of the essential elements or ingredients of the former, as alleged in the complaint or information, constitute the latter, and an offense charged is necessarily included in the offense proved when the essential ingredients of the former constitute or form part of those constituting the latter. Now, in the case of People of the Philippines versus Cruz, GR number 202122, January 15, 2014, the Supreme Court categorically held that when there is a variance between the offense charged in the complaint or information and that proved in the offense as charged is included in or necessarily includes the offense proved, the accused shall be convicted of the offense proved which is included in the offense charged, or of the offense charged which is included in the offense proved. An offense charged necessarily includes the offense proved when some of the essential elements or ingredients of the former, as alleged in the complaint or information, constitute the latter. And an offense charged is necessarily included in the offense proved when the essential ingredients of the former constitute or form part of those constituting the latter. Now, the variance referred to in Section 4 of Rule 120 is a situation where, or contemplates a situation where, the offense proved is different from the offense as charged in the criminal complaint or information, and the offense as charged is either included in the offense proved or necessarily includes the offense proved. Now, in those cases, the accused shall be convicted of the offense proved which is included in the offense charged. The accused may likewise be convicted of the offense charged which is included in the offense proved. Now, an offense charged, again, to reiterate, necessarily includes the offense proved when some of the essential elements or ingredients of the former, as alleged in the complaint or information, constitute the latter. Now, for example, the crime of serious physical injuries necessarily includes less serious or slight physical injury. Now, the crime of murder necessarily includes the crime or offense of homicide. Likewise, the offense of robbery or the crime of robbery includes theft. Now, in relation thereto, an offense charged is necessarily included in the offense proved when the essential ingredients of the former constitute or form part of those constituting the latter. For instance, the crime of theft is included in robbery. Okay, the crime of acts of lasciviousness are included in the offense of rape or in the crime of rape, and also the crime of less serious physical injuries are included in the crime of serious physical injuries. Also, the crime of homicide is included in the crime of murder. Precisely, if the accused in a criminal case is charged with murder, but it was homicide that was proven by evidence, the same accused shall be convicted of homicide, the offense proved. This is because homicide is included in the offense charged, which is murder. Now, in like manner, if a person is accused of homicide, or if the accused is charged in the criminal complaint or in the criminal information of the crime of homicide, but it was the crime of murder that was proven during trial, the accused shall be convicted of homicide only, the offense charged. The accused shall not be convicted of murder, the offense proved. Okay? So that is clear, class. That is clear. All right. Let's proceed to promulgation of judgment under Rule 120, Section 6 of the Revised Rules on Criminal Procedure. Now, question. How should the judgment be promulgated? As provided in the said section, the judgment of the trial court in a criminal case is promulgated in the following manner. First, by reading it in the presence of the accused and any judge of the court in which it was rendered. Second, if the conviction is for a light offense, the judgment may be pronounced in the presence of his counsel or representative, not necessarily in the presence of the accused if it is for a light offense. And lastly, when the judge is absent or outside the province or city, the judgment may be promulgated by the clerk of court. Now, what happens when the accused fails to appear at the promulgation of judgment? Now, in case the accused fails to appear at the scheduled date of promulgation of judgment, despite notice, the promulgation shall be made by, first, recording the judgment in the criminal docket and serving the accused a copy thereof at his last known address or through his or her counsel. Now, what is the effect of failure of the accused to appear during promulgation of judgment of conviction? Okay, now what is the effect, class, if the judgment was for conviction and the accused fails to appear at the said promulgation of judgment? Now, if the judgment is for conviction and the failure of the accused to appear was without justifiable cause, he shall lose the remedies available in these rules against the judgment, and the court shall order his arrest. However, class, you have to remember, as was stated earlier, if the penalty is only for a light offense, then the accused is not personally required to be present at the promulgation of judgment. Okay? Now, in that case, what is the remedy of the accused? The remedy of the accused is that within 15 days from promulgation of judgment, the accused may surrender and file a motion for leave of court to avail of those remedies as provided by the law and the rules. In relation thereto, the accused shall state the reasons for his absence at the scheduled promulgation, and if he proves that his absence was for a justifiable cause, he shall be allowed to avail of said remedies within 15 days from notice. Now, precisely in the case of Cuyo versus People of the Philippines, GR number 192164, October 12, 2011, the Supreme Court held that despite notice, the accused was absent when the MTCC promulgated its judgment on the 25th of August 2009, and pursuant to Rule 120, Section 6, it is only when the accused is convicted of a light offense that a promulgation may be pronounced in the presence of his counsel or representative. In case the accused personally failed to appear on the scheduled date of promulgation despite notice, and the failure to appear was without justifiable cause, the accused shall lose all remedies available in the rules against the judgment. One such remedy was the motion for reconsideration of the judgment of the MTCC filed by petitioner on August 28, 2009. Absent a motion for leave to avail of the remedies against the judgment, the MTCC should not have entertained the petitioner's or the accused's motion for reconsideration. Now, class, it should be underscored that the judgment in a criminal case must be penned and promulgated by the judge during his or her incumbency. Precisely in the case of People versus Garcia, 313 SCRA 279, the Supreme Court held that, granting arguendo that the decision in criminal case numbers R4171 and R4172 was indeed signed by the late Judge Calderon, respondent Judge Buenconsejo, had no authority to promulgate the decision. Judge Calderon ceased to be the judge of the court. Thus, the judgment which he signed cannot be promulgated by another judge. Any judgment or decision is valid and binding only if both were penned and promulgated by the judge during his or her incumbency. Question class. When does a judgment in a criminal case become final? A judgment in a criminal case becomes final when, first, after the lapse of time for perfecting an appeal. Second, when the sentence has been partially or totally satisfied. Third, when the accused has expressly waived in writing his right to appeal. Or, lastly, when the accused has applied for probation. And with that, we are done with trial under Rule 119 of the Revised Rules on Criminal Procedure. Now let us proceed to post-judgment remedies in criminal cases, or those remedies before the finality of judgment in a criminal case. Now, what are these post-judgment remedies in criminal cases, or the proceedings or remedies available before the finality of judgment under the rules? These are a motion for new trial under Rule 121 of the Revised Rules on Criminal Procedure, a motion for reconsideration, likewise under Rule 121, appeals under Rules 122 through 125, the Revised Rules on Criminal Procedure, and probation, Presidential Decree 968. Now let us proceed to the remedy of motion for new trial under Rule 121. Now in People versus Tamayo, 86 Philippines 213, new trial has been defined by the Supreme Court as a proceeding whereby errors of law or irregularities are expunged from the record, or new evidence is introduced, or both steps are taken. Now, when is new trial available? This is provided under Rule 121, Section 1, and states that at any time before a judgment of conviction becomes final, the court may, on motion of the accused or at its own instance, but with the consent of the accused, grant a new trial or reconsideration. Now, what are the grounds for a motion for new trial? This is provided under Rule 121, Section 2 of the Revised Rules on Criminal Procedure, which states to wit, the court shall grant a new trial on any of the following grounds. First, that errors of law or irregularities prejudicial to the substantial rights of the accused have been committed during the trial. Second, that new and material evidence has been discovered which the accused could not, with reasonable diligence, have discovered and produced at the trial, and which, if introduced and admitted, would probably change the judgment. Now, in relation thereto, what are the requisites or elements of new trial on the ground of newly discovered evidence? Now, what are the requisites of newly discovered evidence as a ground for a motion for new trial? Now, in several cases, People versus Ebias, 342 SCRA 675, year 2000. Jose versus Court of Appeals, 70 SCRA 257, 1976. People versus Lee Ka Kim, GR number 148586, May 25, 2004. The Supreme Court has repeatedly held that before a new trial may be granted on the ground of newly discovered evidence, it must be shown that, first, the evidence was discovered after the trial. Second, such evidence could not have been discovered and produced at the trial even with the exercise of reasonable diligence. Third, that it is material and not merely cumulative, corroborative, or impeaching. And the evidence is of such weight that it would probably change the judgment if admitted. Now, if the alleged newly discovered evidence could have been very well presented during the trial with the exercise of reasonable diligence, the same cannot be considered as newly discovered. Now, in relation thereto, it should be important to note that in the case of Tumang versus Court of Appeals, 172 SCRA 328 1989, our Honorable Supreme Court has held that in order that a particular piece of evidence may be properly regarded as newly discovered to justify the motion for new trial, what is essential is not so much the time when the evidence offered first sprang into existence, nor the time when it first came to the knowledge of the party now submitting it. What is essential is that the offering party had exercised reasonable diligence in seeking to locate such evidence before or during trial, but that nonetheless failed to secure it. Now, what is this concept of due diligence in relation to the ground of newly discovered evidence? Now, in the case of Custodio et al. Versus Sandiganbayan, GR numbers 96027 to 28, March 8, 2005, the Supreme Court had ruled that the rules on the revised rules on criminal procedure, the law, do not give an exact definition of what is due diligence and whether the movant has exercised due diligence depends upon the particular circumstances of each case. Nonetheless, it has been observed that the phrase is often equated with reasonable promptness to avoid prejudice to the defendant. In other words, the concept of due diligence has both a time component and a good faith component as well. The movant for a new trial must not only act in a timely fashion in gathering evidence in support of the motion, he must act reasonably and in good faith as well. Due diligence contemplates that the defendant acts reasonably and in good faith to obtain the evidence in light of the totality of the circumstances and the facts known to him. Alright, let us now discuss the grounds for a motion for reconsideration. Now, the grounds for a motion for reconsideration is found in Section 3, Rule 121 of the Revised Rules on Criminal Procedure. And these are, first, errors of law, and second, errors of fact, and which does not require the presentation of evidence, and the motion shall be resolved on the basis of the records of the case. Alright? Now, what are the formal and procedural requirements of new trial or of reconsideration? This is provided under Rule 121, Section 4 of the Revised Rules on Criminal Procedure. And these formal requirements for the filing of a motion for new trial or motion for reconsideration are the following. First, it must be in writing. Second, it shall state the grounds on which it is based. Third, if it is based on newly discovered evidence, the motion shall be supported by affidavits of witnesses by whom such evidence is expected to be given or by duly authenticated copies of the document. And lastly, notice to the prosecutor. Now, what is the effect if the accused fails to comply with the requirements as provided in Section 4? Now, in People versus De La Cruz, 2 SCRA 1119, the Supreme Court has held that failure to comply with those requirements is fatal to the motion for new trial. Alright, we proceed with the effects of the granting of a motion for new trial or a motion for reconsideration. Now, this is provided under Section 6, Rule 121 of the Revised Rules on Criminal Procedure. Now, what are the effects of granting a new trial or reconsideration? First, when a new trial is granted on the ground of errors of law or irregularities committed during the trial, all the proceedings and evidence affected thereby shall be set aside and taken anew. The court may, in the interest of justice, allow the introduction of additional evidence. Second, when a new trial is granted on the ground of newly discovered evidence, the evidence already adduced shall stand, and the newly discovered evidence and such other evidence as the court may, in the interest of justice, allow to be introduced, shall be taken and considered together with the evidence already in the record. And lastly, in all cases, when the court grants new trial or reconsideration, the original judgment shall be set aside or vacated, and a new judgment rendered accordingly. It should also be noted, class, that once a new trial is granted, the original judgment is vacated. The nullification of the original judgment is never dependent on whether or not the new trial results in a new or modified judgment. The mere grant of a motion for new trial or a motion for reconsideration in that case is or operates to vacate the original judgment. Alright, let's proceed with our discussion on appeal under Rules 122 through 125 of the Revised Rules on Criminal Procedure. Now, what is an appeal? An appeal is a proceeding for review by which the whole case is transferred to the higher court for a final determination. The right of appeal is a mere statutory privilege, and only final judgment and orders are appealable. Again, to reiterate, an appeal is merely a statutory privilege. The right to appeal is not a natural right nor a part of due process. Now, what is the effect of this? As a consequence, the right to appeal may be exercised only in the manner and in accordance with the provisions of law. However, while the right to appeal is statutory, once it is granted, its suppression would be a violation of due process. Now, what is the period for taking an appeal, or when should appeal be taken? As provided in Rule 122, Section 6, an appeal must be taken within 15 days from promulgation of judgment or within 15 days from notice of final order appealed from. Now, question: who may appeal? Under Rule 122, Section 1 of the Revised Rules on Criminal Procedure, it provides that any party may appeal from a judgment or final order unless the accused will be placed in double jeopardy. So, the accused may appeal the judgment of conviction. The private offended party may appeal the judgment with respect to civil liability ex delicto or civil liability arising from the crime. Now, question: may the prosecution appeal a judgment of acquittal? As a general rule, no. As the accused would be placed in double jeopardy. Again, as a general rule, the prosecution cannot appeal a judgment of acquittal, as this would place the accused in double jeopardy. Now, by way of exception, where the prosecution may appeal the judgment of acquittal, the first exception would be if the dismissal is made upon motion or with the express consent of the accused. Now, the exception to this exception would be when the accused files a demurrer to evidence on the basis of insufficiency of evidence. Okay? In that instance, the dismissal of the case is with prejudice. Therefore, double jeopardy would apply. Now, second exception to the exception is when the accused moves for the dismissal of the violation of the accused's right to speedy trial or speedy disposition of cases. Now, when the dismissal in those instances, the prosecution cannot appeal it. The prosecution cannot appeal those dismissal because it would place the accused on double jeopardy. Okay, those are the exception to the exception. Now, the second exception to the general rule that the prosecution cannot appeal a judgment of acquittal is that if the dismissal of the criminal case is not considered as an acquittal or based upon consideration of the evidence on the merit. Okay? If the dismissal is not an acquittal, or if the dismissal is not based upon consideration of the evidence on the merit, then the prosecution may appeal the judgment. The third exception, if the question is purely legal, so that should the dismissal be found incorrect, the case shall be remanded for further proceedings to determine the guilt or innocence of the accused. And lastly, if there is a showing of grave abuse of discretion amounting to lack or excess of jurisdiction, a petition for certiorari under Rule 65 may be available to the prosecution. It should also be noted, class, that in criminal cases, when an accused appeals from the sentence of the trial court, he waives the constitutional safeguard against double jeopardy and throws the whole case wide open to the review of the appellate court. Again, in criminal cases, an appeal throws the case wide open for review, and the reviewing tribunal can correct errors or even reverse the trial court's decision on grounds other than those that the parties raised as errors. Precisely, the appeal confers upon the appellate court full jurisdiction over the case and renders such court competent to examine records, revise the judgment appealed from, increase the penalty, and cite the proper provision of the penal law violated, even if these errors or these grounds are or was not raised by the parties as errors. Now, question, class. Can a party in a criminal case change the theory on appeal? The answer is no. In a long line of cases, the Supreme Court held that a party cannot change his theory on appeal nor raise in the appellate court any question of law or fact that was not raised in the court below or which was not within the issue raised by the parties in their pleadings. In relation thereto, the Supreme Court has held that points of law, theories, issues, and arguments not adequately brought to the attention of the trial court ordinarily will not be considered by a reviewing court, as they cannot be raised for the first time on appeal, because this would be offensive to the basic rules of fair play, justice, and due process. Now, it should be also noted, class, that the appeal of the offended party from the civil aspect of the case shall not affect the criminal aspect of the judgment or order appealed from. Question, class. What is the effect of the death of the accused pending appeal? Now, in the case of People versus Paras, GR number 192912, October 3, 2014, the Supreme Court held that upon the death of the accused pending appeal of his conviction, the criminal action is extinguished, inasmuch as there is no longer a defendant to stand as the accused. The civil action instituted therein for the recovery of civil liability ex delicto is ipso facto extinguished also, grounded as it is on the criminal action. Also, class, you should remember that under Rule 122 of the Revised Rules on Criminal Procedure, Section 11 thereof, it states that upon perfection of the appeal, the execution of the judgment or final order appealed from shall be stayed as to the appealing party. Again, upon perfection of the appeal, the execution of the judgment or final order appealed from shall be stayed as to the appealing party. Question, class. What is the effect of appeal by any of several accused? Now, if an appeal is taken by any of the several accused, shall have the following effects. In the case of Garces versus People, GR number 173858, July 17, 2007, the appeal taken by any of the several accused shall not affect those who did not appeal, except insofar as the judgment of the appellate court is favorable and applicable to the latter. The appeal of the offended party from the civil aspect shall not affect the criminal aspect of the judgment or order appealed from, as was discussed earlier. And also, upon perfection of the appeal, the execution of judgment or final order appealed from shall be stayed as to the appealing party only. It should be noted that the benefit of the stay of execution afforded to a co-accused who timely files an appeal cannot be extended to those who fail to file the same. Right? How and in what court should the appeal be taken in criminal cases? Now, if it is the decision of the municipal trial court, it is appealed to the regional trial court by filing a notice of appeal with the MTC who rendered the said decision and by serving a copy of the notice to the adverse party. Now, if it is a decision of the regional trial court in the exercise of its original jurisdiction for offenses with imposable penalties less than reclusion perpetua or life imprisonment, the decision or the judgment is appealed to the Court of Appeals by filing a notice of appeal with the RTC who rendered the judgment and by serving a copy of the notice to the adverse party. Now, if it is a decision of the regional trial court in the exercise of its appellate jurisdiction, it is appealed to the Court of Appeals by filing a petition for review under Rule 42 with the CA. Now, if it is a decision of the RTC where the imposable penalty is either life imprisonment or reclusion perpetua or a lesser penalty for offenses committed in the same occasion or which arose from the same occurrence that gave rise to the offense punishable by reclusion perpetua or life imprisonment, the same judgment is appealable to the Court of Appeals by filing a notice of appeal with the regional trial court and by serving a copy of the notice to the adverse party. Now, from decisions of the regional trial court where the imposable penalty is death, it is appealed to the Court of Appeals by way of automatic review to the CA as provided in Section 122, in Rule 122, Section 10 of the Revised Rules on Criminal Procedure. Alright, what if it is the decision of the Court of Appeals where the penalty is not the death penalty, reclusion perpetua, or life imprisonment? Okay, the decision of the Court of Appeals in that instance is appealed to the Supreme Court by way of petition for review and certiorari under Rule 45 and should only raise questions of law and should raise the errors of the Court of Appeals and not the RTC. Now, in criminal cases decided by the Court of Appeals and the penalty and the Court of Appeals finds that death penalty should be imposed, then it is by way of automatic review to the Supreme Court under Rule 124, Section 13. Now, if the Court of Appeals imposes reclusion perpetua, life imprisonment, or a lesser penalty, it is by way of notice of appeal under Rule 124, Section 13. Right? Let's go to decisions or judgments of the Sandiganbayan. Okay? Where do you file it? How do you file it? Okay? In decisions or judgments by the Sandiganbayan in criminal cases exercising its appellate jurisdiction for offenses where the imposable penalty is reclusion perpetua or life imprisonment, it is appealed to the Supreme Court by filing a notice of appeal. Now, in the Sandiganbayan, renders a decision or judgment exercising its original jurisdiction for offenses where the imposable penalty is reclusion perpetua and life imprisonment, the appeal should be made to the Supreme Court by filing a notice of appeal. Now, in cases not falling in those that I have mentioned, then the decision of the Sandiganbayan should be appealed to the Supreme Court by way of petition for review on certiorari under Rule 45. Okay, again, when should appeal be taken? When should appeal be taken? What is the period for the filing of the appeal? Now, under Rule 122, Section 6, as was stated earlier, the period to take an appeal or the appeal must be taken within 15 days from promulgation of judgment or from notice of final order appealed from. However, it should be emphasized, class, that the rule in the case of NAPES applies with equal force to criminal cases. Precisely, in the case of U versus Samson Tatad, 642 SCRA 421, the Supreme Court categorically held that the NAPES rule applies to criminal cases for the reason that the law, according to the Supreme Court, makes no distinction between the periods to appeal in a civil case and in a criminal case. Hence, added the Supreme Court, when the law makes no distinction, the court also ought not to recognize any distinction. So an appeal in a criminal case may be filed within 15 days from notice of denial of the motion for reconsideration or motion for new trial. Alright, let's proceed to probation. Under Presidential Decree 968 as amended, Section 4 thereof, the law states that the court may, after it shall have convicted and sentenced a defendant or the accused within the period for perfecting an appeal, suspend the execution of the sentence and place the said defendant on probation for such period and conditions it may deem best. No application for probation shall be entertained or granted if the defendant has perfected an appeal from the judgment of conviction. It should be emphasized, class, that in the case of Almero versus People, GR number 188191, March 12, 2014, and in related cases, appeal and probation are mutually exclusive remedies. Implicit in an application for probation is an admission of guilt. Alright, and with that, we are done with judgments under Rule 120 and post-judgment remedies under Rule 121 through Rule 125 and also Presidential Decree 968 or the provisions on probation. Thank you for taking the time to listen to the discussions in this recording, and I hope that you find the same informative and instructive.